Is the 99-1 property ownership split legal or illegal? Today, we will be diving into the hot topic that keeps coming up in the property market scene recently, the 99-1 property split. Some people use it to reduce stamp duty, but is it actually legal? Or could it land you in trouble with IRAS? Stick around and I'll break it down with examples and sources you can check for yourself. Hi, I'm Kai. I help my clients in property planning and investments and share my experiences and analysis in this channel to help people have a better understanding of the property market. So please help me by liking and subscribing to my channel. Thank you very much. Before I proceed, for any of your cases, please don't take my word for it. Please seek legal advice for your own cases, as every case is different and unique and warrants a customized advice from your lawyer. The links to the references and articles are provided at the description, so feel free to have a read from the links provided. The so-called 99-1 arrangement is when two buyers co-purchase a property, one party takes a 99% ownership while the other takes 1%. There are two common arrangements previously. One is specifically singled out as illegal by IRAS, while the other is illegal if the buyer avoided paying the rightful stamp duties when they decouple. This sounds a bit confusing for most people, but let's go through both of them. The first scenario that we'll go through is when the then Minister of Finance, Lawrence Wong, specifically mentioned that it is a tax avoidance arrangement, meaning it's illegal. And IRAS has been getting people to go to their office for coffee for these cases since early last year. Let's discuss one example down here. In this case, a young buyer, a young son without property and without the ability to take a loan buy a new launch property at 100% ownership. Take note that this young adult does not have the capacity to obtain a loan. And because new launch payment schedule is via progressive payment, sometimes the loan only kicks in 1 year later. So the buyer within this period sells 1% of his stake to his mom who already owns a property, but has the ability to take a loan, so that they can both apply for a mortgage together and use the loan to pay the developer subsequently. IRAS is clear that this is illegal and that these buyers are using a loophole to avoid paying ABSD based on the mother's property count. We'll refer such kind of transaction as 100 sell 1 to differentiate the two. The second scenario is where two buyers, for example, husband and wife, bought the property based on a 90% to 1% split. This is totally legal up to this point. And the High Court specifically noted that buyers are free to hold their stake in a 99-1 arrangement. So for people who bought at 99-1, there's no need to worry for now. This is perfectly fine. But problem might arise if they want to decouple. So for example, in this case, the wife wants to sell a 1% stake to buy another property. This is fine unless this arrangement is made to avoid paying more tax. For example, they bought a 2 million property with a 99-1 arrangement, but in actual fact, their secret arrangement is such that they own 50% each. So instead of paying a 24,600 buyer stamp duty when she sells a 50% stake to her husband, she only declared that her stake is 1% and her buyer stamp duty is only $2,200. So in this case, she's underpaying $22,400. Furthermore, if you go on to buy a 1 million property after decoupling, she avoided paying a 20% ABSD because in actual fact, she still owns a stake in another property. So this should be counted as the second property count. And the second property count attracts a 20% ABSD. And this will be $200,000. So in this arrangement, they avoided paying $222,400 in taxes. And this is clearly not allowed. So you might ask, what is allowed? In one article in Straits Times, the link can be found in the description. A tax expert also mentioned that as long as the property buyers act in good faith and avoid secret arrangement to hide their true ownership interests, decoupling is not wrong if a joint owner makes an outright transfer of his share in their property, because this owner who has no longer any property can then buy another without being liable for ABSD. In simpler words, one must really sell off his or her stake without secretly keeping an interest, meaning don't just on paper sell off your stake, but secretly tell your wife or husband that you still own half the property. So if you say you want to sell, you really have to sell. This might not be very clear to some people, so please seek legal advice before proceeding with your property purchase arrangement. How about for people who have already bought in a 99-1 arrangement and wants to restructure your portfolio to own two properties as a couple? There are three options. First is to sell this current property to buy another two property, paying the correct taxes. This is the cleanest and hassle-free. The second option is to still decouple, but you go to IRAS for adjudication, meaning you ask IRAS what is the rate you should be paying. When you do this, you likely will need professional legal help and make sure all the documents are kept properly. But you have to accept there is still some risk that IRAS can still find trouble for them. The third option, some people might still want to decouple normally and hope for the best. But in this case, you have to make sure that your holding is actually really 99-1, and when questioned, you are able to show that this is really true. Actually, it is really good that the court and IRAS have these rulings and they specifically mention what is okay and what is not. This will provide clarity so that we can plan our property purchase safely. So if you are planning your property purchase, please follow IRAS guidelines carefully. So what I'll take away for this video? 1. The paper title is not everything. The name and percentage on the title deed are not the final say. The law also cares about the financial reality and the party's intention behind the transaction. If someone pays 60% of a property, the court can possibly decide that they own 60% even if the paper says that they only own 1%. The second takeaway is that while the 99-1 split is not illegal by itself, using it with the intention of avoiding tax is a red flag. If you want to read in more details, the links of the articles and resources are in the description. And please don't take my word for it. Do seek professional legal advice before restructuring your property portfolio because every situation is unique and different and warrants a detailed advice from a professional. But if you are looking for a professional advice on property matters and do not have an agent, you can contact me at the number above and we can have a no-obligation chat to discuss how we can help you structure you and your family's property portfolio safely to get the best value for your money without getting into trouble. And please help me and my channel by liking my video and subscribing to my channel if you have not done so. I really appreciate it and will encourage me to produce more contents like this. Once again, I'm Kai. See you soon.